Hello, everyone, and welcome to Uncivil Law. For our case today, we have the case of Arthrex versus Smith and Nephew from the Court of Appeals for the Federal Circuit. This case deals with a patent appeal, but the decision of the Court of Appeals is not about the patent. Instead, it's about the decision of the administrative body that decided this within the United States Patent and Trademark Office. In the United States Patent and Trademark Office, when you appeal things from a patent examiner, you go to an internal board called the Patent Trial Appeal Board. This is staffed by a group of administrative patent judges. These people are appointed by the Secretary of Commerce, but this court case finds that that was improper and that they should have been appointed by the President with confirmation by the Senate. So they send it back for further decisions. We're going to read this decision, which deals with when a person has to be appointed by the President and confirmed by the Senate, and also when that is not necessary. So it's a very interesting case dealing with the appointments clause of the Constitution. Who gets to make what kind of appointments? So we're going to read the decision of the Court of Appeals for the Federal Circuit dealing with appointment authority. So let's get started with this. Arthrex appeals this decision and contends that the appointment of the board's administrative patent judges by the Secretary of Commerce, as set forth in Title 35 of the United States Code, violates the Appointments Clause of the United States Constitution, Article 2, Section 2, Clause 2. We agree and conclude that the statute, as currently constituted, makes administrative patent judges principal officers. So an administrative patent judge is also what might be called an administrative law judge. These are people that exist within many federal agencies that hear appeals internally within the agency. And so, although they have a fancy name, this decision would seem to apply to all administrative law judges. So the scope of this decision would have ramifications potentially for many other federal agencies beyond the United States Patent and Trademark Office. We conclude that severing the portion of the Patent Act restricting removal of the administrative patent judges is sufficient to render the APJs inferior officers and remedy the constitutional appointment problem. So this goes to the issue of remedies. How is the court going to solve the problem? Here, the court solves the problem by striking a particular provision of the statute. The statute in question gave limited authority for the federal government to remove someone once they were appointed as an administrative patent judge. But this was a death knell to the nature of the appointment. Because they couldn't be removed, they were not inferior officers because they had no superior officer to remove them. So the court solved the problem by striking the provision of the statute which gave these people immunity from being fired. So under the decision of the Court of Appeals for the Federal Circuit, the administrative patent judges can now be fired at will. Presumably, this would apply to other administrative law judges in similar contexts as well. Arthrex argues that the administrative patent judges who presided over this inter partes review were not constitutionally appointed. It argues that the APJs were principal officers who must be, but were not, appointed by the President with advice and consent of the Senate. The Constitution provides, the President shall nominate, and by, with advice and consent of the Senate, shall appoint ambassadors, other public ministers and counsels, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress of the United States may, by law, vest appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of the department. So we can see that the Constitution sets out a dichotomy. The President has the ability to appoint all officers, but Congress can separate inferior officers from non-inferior officers. So Congress, if they want, can say other people can make appointments by heads of departments. That would be, for example, the Secretary of Commerce. He's the head of the department. So initially, Congress, when they created this statute, said that administrative patent judges were inferior officers and gave the role to the Secretary of Commerce to make the appointments. But here, the Court of Appeals says, no, by their structure, they're actually not inferior officers, and therefore Congress can't sever that, and only the President of the United States can make these appointments, so the administrative patent judges were not constitutionally appointed. Administrative patent judges are appointed by the Secretary of Commerce in consultation with the Director of the USPTO, also known as the Undersecretary for Intellectual Property. The issue, therefore, is whether the APJs are officers of the United States, and if so, whether they are inferior officers or principal officers, the latter requiring appointment by the President as opposed to the Secretary of Commerce. We hold that in light of the right and responsibilities on Title 35, APJs are principal officers. The Supreme Court explained that whether one is an inferior officer depends on whether he has a superior, and inferior officers are officers whose work is directed and supervised at some level by others who were appointed by presidential nomination with advice and consent of the Senate. There is no exclusive criterion for distinguishing between principal and inferior officers for appointment clause purposes. The court in Edmund emphasized three factors: where the appointed official has the power to review and reverse officers' decisions, the level of supervision and oversight, and the appointed officer's power to remove officers. These factors are strong indicators of level of control and supervision appointed officers have over officers and decision-making on behalf of the executive. The extent of discretion or control that relationship is central consideration as opposed to just relative rank of officers because of the accountability. The only two presidentially appointed officers that provide direction to the USPTO are the Secretary of Commerce and the Director, otherwise known as the Undersecretary for Intellectual Property. So here the United States Supreme Court has pointed to several factors that can decide whether or not someone is an inferior officer or whether or not someone is a principal officer. The United States Supreme Court has pointed to oversight and control as one of the designating factors, and that factor seems to be the authority issue that was at issue here because the APJs did not have sufficient superior people reviewing their work to be deemed inferior. Because they were directly making actions, they were the principal officers and therefore had to be presidentially appointed as far as the court determines. The situation here is critically different from the one in Edmund. In Edmund, the Supreme Court considered whether military judges on the Coast Guard Court of Criminal Appeals were principal as opposed to inferior officers. There, the Court of Appeals for the Armed Forces, an executive branch entity, had the power to reverse decisions by the military judges. And while the Judge Advocate General, a properly appointed executive officer, could not reverse decisions of military judges, he could order any of those decisions to be reviewed by the Court of Appeals for the Armed Forces, a presidentially appointed executive branch Article I court. The court therefore deemed it significant that judges of the Court of Criminal Appeals had no power to render a final decision on behalf of the United States unless permitted to do so by another executive officer. The extent to which an officer's work is supervised or overseen by another executive officer also factors into determining inferior versus principal officer status. The director has the authority to promulgate regulations governing the conduct of the inter-parties review. The director's administrative oversight authority is similar to the supervisor's authority that was present in both Edmund and Intercollegiate. In Edmund, the Judge Advocate General expressed administrative oversight and had the responsibility of prescribing uniform rules of procedure for military judges. Likewise, in Intercollegiate, the Library of Congress was responsible for approving the copyright royalty judges, procedural regulations, and overseeing various logistical aspects of duties. The Supreme Court viewed removal power over an officer as a powerful tool of control when it was unlimited in Edmund. Under the current Title 35 framework, both the Director of the Patent Office and the Secretary of Commerce lack the unfettered removal authority. So again, the court is pointing to the lack of supervisory control and deeming the lack of ability to fire these people or otherwise control them because the way the statute was written gave them unfettered control and limited the ability of the Secretary of Commerce to fire them. They were principal officers in the view of the Court of Appeals. The only actual removal authority by the director or secretary have over APJs is subject to limitations by Title V of the United States Code. Title V of U.S. Code, incidentally, deals with most federal employees. Most federal employees are Title V employees in terms of the executive branch. Title 35 does not provide for statutory authority for removal. Title 35 deals with the patent law specifically. Instead, 35 U.S.C. Section 3 provides that officers and employees of the office shall be subject to the provisions of Title V relating to federal employees. So, as you might expect, Patent Office officials are subject to Title V, as are most officials. No big deal there. No one disputes that Title V creates limitations on the Secretary or Director's authority to remove an APJ from his or her employment at the USPTO. Specifically, the APJ may be removed only for such cause as will promote the efficiency of the service. The government argues that the Secretary's authority to remove APJs from employment for such cause as will promote the efficiency of service, the same standard that applies to any other federal employee, underscores that APJs are subject to significant supervision and control. Here, the APJs can only be removed from service for such cause as will promote the efficiency of the service, meaning for misconduct that is likely to have an adverse impact on the agency's performance of its functions. The D.C. Circuit in Intercollegiate determined that given the CRJ's non-removal and finality of their decisions, the Librarian of Congress and Register of Copyrights supervision's functions still fall short of the kind that would render them inferior officers. Likewise, because the APJs issue decisions that are final on behalf of the executive branch and are not removable without cause, we conclude the supervision and control over APJs by appointed executive branch officials in similar ways mirrors that of the CRJs in Intercollegiate. Having considered the issues presented, we conclude that APJs are principal officers. The lack of any presidentially appointed officer who can review, vacate, or correct decisions by the APJs, combined with their limited removal power, leads us to conclude, like our sister circuit Intercollegiate, which dealt with similarly situated CRJs, that these are principal officers. While the director does exercise oversight authority that guides the APJs procedurally and substantively, and even if he has authority to designate the APJs from the inter-party review, we conclude that the control and supervision of the APJs is not sufficient to render them inferior officers. The lack of control over APJ decisions does not allow the president to ensure the laws are faithfully executed because he cannot oversee the faithfulness of the officers who execute them. These factors, considered together, confirm that APJs are principal officers under Title 35 as currently construed. As such, they must be appointed by the president and confirmed by the Senate. Because they are not, the current structure of the board violates the Appointments Clause. So this is a pretty big deal on its initial face. The Court of Appeals is saying that the entire APJ system, as currently appointed, is invalid because they are not inferior officers. They're rather principal officers. So now the court has to figure out what to do about it. How do we fix this problem? Do we simply strike it out? Do we say they all have to be appointed? What is the remedy this court is to apply? So let's go to the remedy section to see how they address this discrepancy that they've created. The government also suggested partially severing 35 U.S.C. Section 3, the provision that applies Title V to the officers and employees of the USPTO. We think that this narrowest viable approach to remedying the violation of the Appointments Clause. Severing Title V's removal restrictions might arguably be achieved by either severing the words officer and or concluding that those removal restrictions are unconstitutional as applied to the APJs. The government recommends a partial invalidation, namely that they would sever the application of Title V's removal restrictions to the APJs. This as-applied severance is the narrowest possible modification to the scheme Congress created and cures the constitutional violation in the same manner as Free Enterprise Fund and Intercollegiate. Title V's removal protections cannot be constitutionally applied to the APJs, so we sever that application of the statute. So here there is a general section of this patent law that says, Title 35, that all people appointed to the Patent Office are protected by Title V. But rather than striking it out completely, they say that's simply inapplicable to the administrative patent judges. So the members serving on the Patent Trial and Appeal Board and also the Trademark Trial and Appeal Board are no longer protected by our Title V and therefore presumably can be fired at will with or without cause. Also, this would apply to most administrative law judges, it seems to me, in most federal agencies. So I would suspect that most APJs, ALJs, or whatever they're called in their respective agencies are no longer covered by Title V's protections and can be removed without cause. So that is a pretty big deal as it applies to these judges because they no longer have the protections of the removal authority under Title V. The decision to partially invalidate the statutory removal protection limits the effect of the severance to APJs and their removal protections. The choice to sever and exercise a portion of the statute as unconstitutional in order to preserve the statute as a whole is limited and does not permit judicial rewriting of statutes. We hold that application of Title V's removal protections to APJs is unconstitutional and must be severed. And while we are convinced that Congress would preserve the statutory scheme it created for reviewing patent grants and that it intended for APJs to be inferior officers, our severance of the limits achieves this. So that is the case of Arthrex versus Smith and Nephew from the Court of Appeals for the Federal Circuit, holding that administrative patent judges before the Patent Trial and Appeal Board, and by logical extension, judges before the Trademark Trial and Appeal Board, and by extension, administrative law judges before most federal agencies may be, under the current way they're structured, considered to be principal officers. And one of the ways that they've decided to solve this problem is by saying that, at least for the administrative patent judges, that they are not protected by Title V protection. However, as it relates to other administrative law judges, this will not be heard by the Court of Appeals for the Federal Circuit. The only reason the Court of Appeals for the Federal Circuit is hearing this case is because this originated from a patent issue, and so all patent issues are decided by the Court of Appeals for the Federal Circuit. However, every other administrative law judge will probably be heard by the Court of Appeals for the DC Circuit. So it will be interesting to see if the Court of Appeals for the DC Circuit, in what I am sure will be litigation that will be spurned out of this, as other agencies take note of this and perhaps try to apply it to their officers, whether the Court of Appeals for the DC Circuit will follow this lead from the Court of Appeals for the Federal Circuit, and whether or not this will cause a conflict that might cause Supreme Court review. So it will be interesting to see what happens. But in the meantime, administrative patent judges can apparently be fired with or without cause at any time. So all those people that took those jobs are now in a less secure place. So that is the end of the story, and we will see what happens next.